Good afternoon, everybody. My name is Ross Pitcoff of the Pitcoff Law Group. And for those of you that don't know, we are a New York City-based law firm that specializes in commercial litigation, as well as arbitration internationally and domestically, and corporate transactional work as well. We also have offices located in New Jersey and the state of Florida. And today, I'm going to be presenting on the topics of litigation, arbitration, or mediation. Which one is best for your situation? Now, as a general overview, when we deal with disputes and alternative ways of going about the dispute resolution process, you can usually, once you're ready to bring a claim, either you file a claim in court or you can go through an alternative dispute resolution mechanism. And that could either be via arbitration or via mediation. So for today, we will be covering a few topics. First and foremost, we'll start off with the definitions of mediation, arbitration, and litigation. Then I'm going to walk you through just a few quick quotes attributed to people that you've all likely heard of from the past. We will then shift gears into the benefits and detriments of mediation, arbitration, and litigation, which really is the best direction to head in. So we'll talk about actually drafting a clause in an agreement that could cater itself towards litigation, mediation, arbitration. We'll talk about things like fee shifting and forum selection, and really put somebody in a position where if they wanted to, they would have an idea about how they could ensure that if they ever enter into an agreement, they could choose the forum that's right for them. Starting at the top, let's go through a few different definitions. First off, what's litigation? So litigation is defined, and we've all heard litigation. We've all heard of going to court. We've all heard of federal court and state court, and maybe you've heard of civil courts, and you've heard of all different types of courts, courts of claim, etc. And litigation is defined as a formal legal process where disputes are resolved in a court of law with a judge and sometimes a jury, because you can have a bench trial, which doesn't include a jury, making binding decisions about legal arguments and evidence presented by the parties. Decisions are appealable based upon an alleged misapplication of the law, though not the facts or evidence. Then we have arbitration. Now, arbitration is different than litigation in that it's a private dispute resolution process. So it doesn't deal with the court system. You're not going through a public filing. It's a private resolution process where one or more arbitrators make a binding decision after hearing arguments and reviewing evidence, which often offers a faster alternative to court litigation. Then we have mediation. Mediation is a voluntary and confidential process where a neutral third-party mediator helps disputing parties reach a mutually agreeable outcome without imposing a decision on them, meaning that it's non-binding, meaning that just because a mediator makes a suggestion about how the parties should ultimately conclude their dispute, they don't actually need to listen to this. So I pulled up what I thought were some interesting quotes concerning litigation, mediation, and arbitration, and then I've got one of some satirical nature, which I think you'll appreciate as well. Attributed to Benjamin Franklin, the only winners in litigation are the lawyers. I probably shouldn't be quoting that, but of course, hopefully he said this in jest. Lawsuits consume time, money, and moral courage, leaving bitterness and resentment behind. That's Chief Justice Warren Burger from the Supreme Court. The third is discourage litigation. Persuade your neighbors to compromise whenever you can. Point out to them how the nominal winner is often a real loser in fees, expenses, and waste of time. And that comes from Abraham Lincoln. And what you might see as a common theme is that at the end of the day, while litigation is a process where one party can ultimately get what they're entitled to, if there's a way to resolve a claim earlier on, if there's a way to resolve a claim via an alternative means out of court, that often is the best way to do so. But sometimes it's simply not practical, and when it's not, then it is necessary, unless there's a provision stating otherwise in a contract, that one does go to court and one takes a claim through trial. Mediation, some interesting quotes. In the middle of difficulty lies opportunity. I think that's very true. And this comes from Gandhi. Mediation is one of the most effective tools of nonviolence. It can turn parties away from conflict towards a more constructive resolution. And we'll get into mediation, but oftentimes that is the case. Okay, arbitration. Arbitration is a private system of justice. It allows parties to craft their own method of dispute resolution, and that's attributed to Chief Justice John Roberts. Arbitration is to justice what lightning is to the lightning bug, Justice Oliver Wendell Holmes. So interestingly enough, it seems that even though you have a lot of these individuals involved in the court system, so Abraham Lincoln was an attorney, you have Chief Justice John Roberts, we have Justice Oliver Wendell Holmes. They all seem to allude to litigation as something that is a long and costly process. And there even appears to be a bent for utilization of mediation and possibly arbitration when it makes sense. This one is attributed to Ambrose Bierce, who was a Civil War soldier. He is also the author of The Devil's Dictionary. And if you've never heard of it, I encourage you to take a look. He's got some really funny, great quotes, such as one being, "Death is not the end, there remains litigation over the estate." With respect to lawyers, he actually provides a definition that states, "one skilled in circumvention of the law." Enough with the self-deprecation for today. We are now going to jump into the substance of these three different means and mechanisms to resolve disputes. We'll talk about the pros and cons of each, how they distinguish themselves from each other, and then we will move on to the more strategic portion of today, which will be discussing how to craft a provision in an agreement that will give you the ability to litigate or resolve a dispute the way you wish to do so. What I will say is, generally speaking, what we're going to talk about in the generalities, if you're a litigator, if you're an attorney listening to this and you litigate, this is going to be very basic. Don't really think you're going to learn anything new. Although perhaps at the point of the strategic area, when we're really breaking down means of providing very good forum selection clauses and dispute resolution provisions, it might be useful. If you are a professional in any field, if you are a business owner that's curious to know how you can protect yourself when it comes to ensuring that disputes are worked out a certain way, then this is going to be a valuable process for you. And you'll also learn about different options you have when you need to resolve a dispute. And one thing this does not consider today is the issue of simply just trying to resolve disputes on your own, right? I mean, often attorneys will send what's called demand letters to opposing parties that unpack the factual backgrounds of issues, unpack the causes of action that a party indicates it's going to allege in court if there's not a resolution. And sometimes that can lead to a dialogue where there's a negotiation and a settlement agreement is entered into. In those situations, you don't have to deal with mediation, arbitration, or litigation. Of course, the idea with out-of-court dispute resolution such as that, there's no guarantee that you're going to reach any outcome. But often we always recommend trying this as the initial step in a litigation or dispute resolution process. So mediation is interesting because when you're working through the mediation process, it's a non-binding process. So when a party says, "I'd like to initiate mediation," or "I wish to go to mediation," usually what happens is you can either do so on your own. So independently, you or through your company or through counsel can reach out to an alternative dispute resolution body such as the AAA or JAMS, which is the AAA is the American Arbitration Association, and you can initiate mediation. Through that process, the alternative dispute body resolution will give you a list of suggested mediators. It will discuss their experience. It will discuss their hourly rates. You'll be able to get a little CV of everybody involved, and the parties work towards picking a mediator that they both agree upon. If they can't, then the alternative dispute resolution body can wind up picking the mediator for everybody and proceed from there. Now, mediation is a much less formal process than litigation and even arbitration. So generally speaking, if you do engage in mediation, and by the way, you don't need to go through an alternative dispute resolution body. You can simply call up an attorney or a retired judge that's a mediator, and you could schedule this on your own. When a mediator is agreed upon by both parties, usually there will be an initial call with the attorneys to discuss the parameters of what the mediation would look like. There's usually a mediation statement that the mediator asks for. And in that instance, that's a statement where each party is unpacking the details of the dispute. They're unpacking the details of the relief they're seeking, and they're then sending this to the mediator so that the mediator can get familiar with the dispute, understand the claims from both sides, and get a sense of how far apart the parties truly are. Now, sometimes these mediation statements are confidential, meaning that the mediator will not have the parties share them. Other times, the mediator will allow the parties to share them. Ultimately, it's not the mediator's decision, it's the decision of the parties and what they agree to. So if the parties say that they do want to keep these statements confidential, that will happen. If they don't, then the statements are shared amongst each other. Sometimes the benefit of sharing the statements is it gives the other party an idea of where their adversary is coming from. One benefit of mediation, even if it doesn't resolve, is that it generally will give the parties an idea of what they can expect if the case were to go into litigation and possibly go to trial. So you'll have an opportunity to have this third party as a mediator who, again, is going to be a very experienced attorney, let's say in business disputes, or is going to be a retired judge who sat on the bench. And during the mediation itself, you'll kind of get a sense of where the mediator is leaning, what they're there to serve the role to negotiate the parties to a resolution, but they also kind of give you an idea of well, what can I expect if a judge were to hear this, or what might a jury think of this, right? So after the mediation statement's prepared by both sides, it'll often be submitted, and then typically there will be a day for mediation. Now, this day and age, mediation can be conducted in person. It could also be conducted via Zoom, and it really depends on what the parties want, absent a contractual agreement stating otherwise. And even then, so long as the parties both agree to forego, let's say, a requirement to mediate in person in a specific venue, you can have a virtual mediation as well. So in this instance, let's say that both parties have submitted their mediation statements, and they are now preparing for the next step. What is that next step? The next step will be an in-person mediation with the mediator. Depending on the size of the claim, depending on the evidence review, depending on the distinction about how far apart the parties are, mediation can last for a couple of hours. Mediation can go all day and well into the night. I can recall a mediation sitting until 11:45 and still not actually reaching a resolution that day, but the resolution wound up being reached the next day after we got to a point that evening of where we were very close to the end. So what to expect during a mediation? During a mediation, you can expect to have a lot of ups and downs and have a lot of lulls. So oftentimes the mediator will bring the parties into a room together to first just talk to them, to hear an initial opening statement by each side. So that way there can be a positioning of what each side believes to be their grievance and what they're entitled to as damages. But if it's a very adversarial relationship, the mediator might split the parties up before the mediation begins. So for a party that's absolutely adamant that they do not want to see their adversary, the mediation process can be interesting because you can set it up where you never have to do so. You just can be in a separate room and then sit with your counsel and essentially proceed from there. Regardless, assuming that the parties do meet together, they're broken up, then usually they will be broken up at one point or another into separate rooms. The mediator then will speak confidentially with each side to start talking about the case, to start talking about the facts, extracting more information, getting a sense of where the parties really want to wind up, what they're willing to do, how much leeway they have off of their initial demands to see if it's possible that they can go back and forth to reach a resolution. Often during the mediation process, there is something known as bracketing that could be implemented. Bracketing is where you take financial numbers. So let's assume this isn't a dispute that involves the transfer of assets or involves taking over a company or shares in stock and all those things. We're just talking about pure money damages. You could actually have a range that the parties sort of agree to and stagger and bracket to that they'll deal with for the rest of the day. So one party might be at, let's say, $50,000, the other party might be at $150,000. And now we kind of use those as the parameters of getting to a resolution. And if we bracket properly and settlements go back and forth, the parties may wind up at $100,000. Bracketing doesn't always happen, and there's more details to that. It's a bit more nuanced, but it is a potential avenue to use when you're involved in mediation. Now, what are the benefits and detriments? Why choose mediation over anything else? Mediation, the benefit is if you resolve your dispute via mediation, you never have to worry about going to court. You don't have to worry about a public filing, which we'll talk more about later. You don't have to initiate arbitration, which can be expensive. And you have flexibility in terms of spending a day with the other party, whether in the same room or not, and using this mediator to ultimately reach an outcome that really works for both sides. If you're able to do that, then most likely the mediation cost will be far, far less significant than if you arbitrated or litigated. So there's a significant cost-saving mechanism in place. What are the detriments of mediation? Well, mediation is non-binding, meaning that if one party agrees to a number after days or after a full day of negotiation and the other party doesn't, the mediator can't enter an order or a judgment saying, I am forcing you to accept this. So if both parties don't agree, then the mediation's off. There's nothing further that can be done, and you will have to go to arbitration or go to court in order to obtain an outcome. So the benefit being, if it resolves, then usually you've ultimately concluded your matter on very favorable terms, as you had to spend significantly less than you would have otherwise, and you're getting an outcome that you were looking for. But if it fails, then now you also spent the money on the mediation because there's no guarantee, and you really haven't necessarily made any progress other than to say you might now be equipped with a much better idea of what might happen if you were to go to trial. So that value in and of itself might make sense to have mediation, even if it doesn't resolve, because you'll be in a better position in terms of what to expect through the litigation process. You might have gone into mediation thinking that you might be able to obtain a certain amount in a judgment, or you might be entitled to, certain chattels in the amount of XYZ, only to feel after speaking with this retired judge that perhaps I was a little more bullish than I anticipated, and my counsel had given me that advice, but I really wanted to see what a third party would say. So mediation is often not for naught. Again, if it's not a settlement on that date, you could still settle somewhere down the line, and perhaps the mediation creates the foundation for it. And also you get the added benefit of getting a better sense of where things might wind up should this matter actually proceed to the judicial process. Now, litigation is what everybody knows best. Litigation constitutes going to court. So it's the courtroom, the grandstanding, the judge, and the jury. And you've seen it on television a million times. And there's the Lincoln Lawyer, and there's Billions, and there's all television series and shows depicting the court process. Some of it's somewhat accurate. Some of it's a little bit off. Some of it is, safe to say, just completely out there in the ether. Reality of the court process is that an aggrieved party files a complaint with court. They pay a fee to do that, but the fees that they have to pay to the court system are just filing fees because it's a public system. The defense then is required to appear in the case by filing an answer, and the parties go through a process that is very strict with respect to discovery, when depositions need to occur, when documents need to be disclosed, and then ultimately the parties have options to do things such as filing a motion to dismiss, a motion for summary judgment. If the case gets to a point where it doesn't resolve during its lifeline, ultimately there will be a trial. Now, federal courts tend to move much more quickly than state courts. Federal courts utilize what's called the federal rules of civil procedure with respect to how much time do I have to do XYZ, when do I need to file a motion? When am I allowed to do things? You look at the federal rules of civil procedure. Excuse me. In state courts, you're looking at the state procedural processes and rules. So for example, in New York, that's the New York civil practice laws and rules. In each state, you generally follow the case law and the rules, the statutes of the state, unless you have a federal question in issue. And in that case, you're looking to a federal statute for relief, and therefore that federal statute is going to govern. With respect to the legal process through the court systems, what are the benefits? What are the detriments? Well, the benefits are that no matter what, when you're in court, you're going to have the opportunity to appeal an outcome. So if there's a motion that's filed, whether it's a discovery motion, whether it's a substantive motion to dismiss or for summary judgment, you have options. You can file a motion to re-argue and renew, where you go back before the court to say the judge applied the law or misapplied the facts, or there's new information, or misapplied the law, I should say, or there's new information we wish to bring to the court's attention. You also have the opportunity to appeal. So whether that's a trial verdict, whether it's an outcome on a motion, you have a right to file a notice of appeal and then to perfect your appeal, which means you are now going to the appellate courts and you are asking the court to review the underlying case to determine whether or not there was a misapplication of the law. Now, that option, that right that you have is very important, because if it turns out that the judge did make a mistake, then there is a safe harbor essentially that allows judicial review by another layer of judges who can then essentially remand the case back down to the civil courts with an ultimate ruling. So the other benefit is that you're paying your attorneys, you're paying the filing fees, but it's not like you're paying a judge. It's not like you're paying additional fees that go to the courts for the opportunity to be heard before them. And generally, the court process can take anywhere from 1 to 3 years to get to a trial. 1 year, frankly, is a very short period this day and age, although it can happen. Federal court's better than state court, but your case can literally be languishing for 2 to 3 years before trial date is actually set. So when you are a litigant and you're considering things like this, you're going to want to, consider, do I want to take the chance of my case remaining in litigation for that period of time? If you happen to settle the case earlier on, great. But otherwise, you've got a long journey ahead. And then, of course, the dockets for public filings are public. So that means that it's possible that any litigation that's filed could show up in a Google search. We find that especially with federal court cases, they do wind up coming up from an SEO perspective. So certainly from a reputational perspective, it's something to consider. That's the reality. If you're going to file a case in federal court, most likely it's going to come up in some sort of Google search, and state court as well. It's just that it doesn't always come up at the top of a page one, but it's certainly something that can be searched. If somebody runs a background report, any judgments are going to appear And, litigation is something that's fair game for being out there in the ether, or out there in the universe, I should say. So benefits are that you can appeal, and that you essentially can have your day in court and then get that option to appeal, and you don't have to pay additional fees. Arbitration. What is arbitration? So arbitration is a private and confidential process. Unlike litigation, there's confidentiality essentially baked into arbitration. The entire process itself is considered confidential. Now, with respect to arbitration is interesting because there's much more leniency with respect to the rules. There's no civil practice law and rules that you need to strictly adhere to. AAA has its own rules for complex matters of commercial litigation. JAMS has their own rules. But they afford the parties a lot of flexibility to essentially come to an agreement as to timelines for discovery, as to the scope of what's to be discoverable, as to whether or not there will even be depositions, as to whether or not there will be post-hearing pre-judgment motions to be filed. So the parties can be a lot more creative in terms of the scope of how they're to produce evidence, what the extent of the evidence is going to be, and if there's a dispute between the attorneys or the parties about that scope, then the arbitrator can make a ruling. What is the benefit of arbitration? Well, arbitration in a way is a really sophisticated process. Similar to mediation, you do work through an alternative dispute resolution body, such as JAMS or the AAA. The AAA will, let's use them as an example, because we often are in front of them. They will provide you with a list of recommended attorneys. Both parties then need to review those recommended arbitrators, who again are either retired judges or attorneys that are sophisticated and can deal with complex matters in the field we're dealing with. And the parties will then rank the order of the arbitrators that they wish to select. Now, sometimes in arbitration, there could be one arbitrator that makes a decision. Other times it could be a panel of three. And to determine or know which one it's supposed to be, often you will look to your agreement or contract entered into. And that's where you're really going to want to see what was said in your contract. Is there supposed to be a panel of three? Is it supposed to be one, etc.? The AAA, if the parties can agree on an arbitrator, great. If they can't and they just put in their rankings, the AAA will ultimately select an arbitrator, and that arbitrator will be assigned to the case. The arbitrator will then reach out to the parties. There will be an initial case management conference where there's a brief conversation about the summary of the case, about the positions of the parties. I should also mention that in arbitration, a party files what's called a statement of claim. It's essentially akin to a complaint that you file in court, but ultimately it has a different name. And then the defendant, in arbitration called the respondent, then can put in an answer and any counters or any replies that they wish to. After the initial case management conference, there will be in place an order that lists all the scope of what's going to be exchanged and a timeline for when that will take place. And the arbitrator usually likes to have status conferences throughout the lifeblood of the arbitration. Here's where it gets really interesting. Unlike a case that's going to court, arbitration usually can have a hearing, which is similar akin to a trial. A hearing can take place anywhere from 6 months to a year down the road. That's a much faster timeline than litigation. So unlike the litigation process where you could be stuck for a couple of years, you actually could wind up with an award in arbitration within an 8 to 10 month period of time. So that's certainly something that's very valuable with arbitration. Arbitration award, which is the judgment, is essentially non-appealable. So if you don't like an outcome in arbitration, too bad, you don't get to appeal it. Now, there's an exception. The only way you could appeal a decision on an award in arbitration is if you allege what essentially arises to undue process. The arbitrator was arbitrary, the determination was arbitrary and capricious, the arbitrator was subject to some undue influence, there was fraud. It has to be something extremely egregious for you to be able to go into court, because that would be the process. There's an award. You'd have to go into court, allege that your arbitrator was arbitrary and capricious or committed some sort of fraud or was participating in an undue and unright manner. And then a judge will actually determine if that's the case. 9 times out of 10, that's not going to be the case. So arbitration awards are generally considered to be not binding and non-appealable. The other consideration for arbitration is that it is a heck of a lot more expensive than court most of the time. And why is that? The court system, which is a public system, arbitration is private. That means you pay the arbitral body to initiate the arbitration. You're also paying the arbitrator's fees. So arbitrators, whether they're attorneys or retired judges, have hourly rates. And those hourly rates are taken into consideration. So if there's a panel of one arbitrator, then the fees are going to be lower. If there's a panel of three, that means the parties are splitting the cost for three separate arbitrators. Benefits of arbitration, you can get a more expedited outcome, and you can know if it's a benefit that there's not an appeal that's available. The decision's the decision, so you can move along quickly, and then you can domesticate the award in a state or federal court in order to collect on it if the opposing party is refusing to adhere. Detriments are, of course, it's going to be a lot more expensive, and the potential detriment is that you can't appeal. Generally speaking, all of the details of the statement of claim are not going to be filed in the court system, so it's not like you have to worry about that coming in any searches on Google. That's something that may or may not be significantly valuable depending on where you are in the arbitration, if you're the complainant, if you're the respondent, et cetera, et cetera. So contract drafting for optimal dispute resolution. What are we talking about there? What does this all mean? How does this play out? How do I know where to go and what to do? Let's say you're a business owner or you're an employer, and you're entering into some sort of an agreement. It could be with an employee. It certainly could be as a business owner, you're entering into an agreement with another party. So a vendor, a contractor, a manufacturer, anybody that you're going to do business with, essentially, you should be signing off on a contract. And when you sign off on a contract, there's usually something in that contract called a dispute resolution clause. And that dispute resolution clause, you're always going to want to review it to make sure it includes certain things. And then this is where, if you're involved in the creation process, where you're going to have your attorney get involved in the creation process or the editing process or the modification process of that provision, there are certain things that you can consider. I'm a business owner in New York. So if there's going to be dispute, number one, the first thing I want to make sure is that New York law governs, right? As a New York citizen, as a business owner in New York, I want to be sure that New York law governs my disputes. So that's something that I want to consider. So you'll often see something that will say something to the effect of, all claims or disputes herein shall be governed by the laws of the state of New York, or the laws of the state of Florida, or the laws of the state of New Jersey, right? Number one. Number two is jurisdiction and venue. Well, that's nice to know that the laws of, let's say, New York are governing this claim. But where is this dispute going to be heard? Okay, well, that's where we want to also reference that any and all disputes arising out of this agreement shall be brought before the courts of the state of New York, shall be brought before a court of competent jurisdiction in the state of New York. So using the word shall, it's mandatory language, it's always recommended, and listing the state where you wish to bring a claim is very, very important. To take it a step further, so that's your jurisdiction. Now let's discuss venue. What is venue? Venue alludes to the specific county where we want the dispute to be heard. So if I'm a New York City business owner, I want all claims being subject to the laws of the state of New York. I want any dispute resolution to be resolved in the state of New York. And I want all disputes to take place or to be initiated in the county of New York. Now, whether that's arbitration, mediation, litigation, it doesn't matter. That's something to decide after this or with this concurrently, but that's something to consider. What else do we want to add? We want to be certain there's something called forum nonconvenience. That is when a party that's in another state, let's say, so let's say you're contracting with a company in California, and we have those provisions set up, and we sue them in court, and they come in, and of course, this day and age with the virtual components, things are shifting, but still, they come in from California, and they come to the court and say, Your Honor, we respectfully request that this matter be taken out of the New York court system because this is a non-convenient forum for us. We shouldn't be forced to litigate here. And they provide a whole, bunch of information why. Well, this company might be in New York, but this used to be another company, and this dispute occurred in California. The parties were all in California. Everything suggests that this actually belongs in California. Well, what we want to do in a contract is we want to specifically state that parties waive. So the parties waive, there's a full waiver of any claim based upon forum nonconvenience. And the idea being is that we want it to be known that no party can come in later in time. They've signed this contract and say that they're not going to be subject to the New York courts for any reason whatsoever. So that waiver will be very important. Fee shifting is something else that you'll want to consider in a provision like this. Who do we want to be responsible for paying court costs, paying attorney's fees? Do we want to leave it open so that each party just pays their own attorney's fees? Or do we want a provision in there that says that the losing party in any litigation will be forced to pay the attorney's fees of the successful party? So that's something to consider. Now, of course, the detriment is that if it turns out you're in the wrong, you're going to wind up paying not only your own attorney's fees, but the other party's attorney's fees. However, shifting provision, and the benefit, of course, is if you are an innocent party that was wronged and you're successful through that process, you get to recover not just the amount you lost in damages, but also your attorney's fees as well. Another consideration with the fee shifting provision is it could serve as a potential deterrent, because a bad faith actor that might be trying to file suit or initiate an arbitration simply to put pressure or take advantage will now know that we'll have to think twice about this, because they're going to run the risk of, if this matter continues through to the end and they lose, then they're going to have to pay their own attorney's fees and the fees of the other party. So a fee shifting clause generally is a good idea, because not only does it serve as a deterrent, but if you are successful and do need to initiate a process via litigation or arbitration, you can recover fees. We've gone through a lot now, but now let's move on to the final component, and that is, what do we wish to do? Do we want our claims to be mediated? Do we want our claims to be subject to arbitration? Do we want to go to litigation? You can actually pile mediation or put together mediation with something else. So, for example, you could have a clause requiring mediation to resolve a dispute, and then if mediation is not successful, the parties will or shall be subject to binding arbitration in the state of New York, as an example. You can have a mediation provision and have nothing else. If there's a mediation provision and mediation fails, well, if there's nothing else in the provision, then litigation in the court system would be the proper forum to proceed from there. So, generally speaking, your best bet, if you're ever going to put a mediation agreement into a contract, you'll also want to account for what happens if mediation is not successful. If you're not interested in mediation and just want the parties to directly go to dispute, to either litigation or arbitration, skip the mediation process of including that in your contract. Now, with respect to litigation or arbitration, there's a lot of considerations to really put out into the universe. I think the most important things to consider is, number one, confidentiality. What type of agreement do I have? Is this an agreement where both parties are engaged in matters that are so intimately entwined in trade secrets and in items where if there was a dispute, if this went into the court system, it would be bad for everyone? Well, in that instance, you're probably going to want to have a mandatory arbitration clause, so that way there's a confidential process to resolve a dispute. Similarly, if one party is highly concerned from a reputational perspective, then their best bet is to try to negotiate an arbitration clause in their agreements. If, on the other hand, you're a bit suspect of the party you might do business with, that probably in and of itself is justification not to do business with that company or individual. But, if you're worried and you're thinking, I don't know that I trust them, I'm going to enter into this agreement because I want to take the risk, maybe then you want to ensure that you can litigate claims publicly, because you know what, if you're concerned they're bad faith actors, again, I wouldn't recommend you get into business with them if they are, but then you'd be able to file something that winds up being public and is in the public forum, just so that other people can become aware that, these are not people we want to do business with. So that's a consideration. Also, if you have significant cost concerns, you may not want to arbitrate, because the reality is arbitration is expensive. If a company has deep pockets, they're probably not too concerned about arbitration. But if you're a small business owner, then the reality is if you do arbitrate, you're going to have to you likely will be expending much more in fees because you're going to pay the arbitrators. One way to combat the overall cost certainly is to, one, have a fee shifting clause, but two, it's to also limit the panel of arbitrators, limit it to 1 versus 3. And you can put that in the provision. You can make clear that there will be a panel of 3, or there will be 1 arbitrator that's rendering a determination. So that's a way to sort of ameliorate that risk. So if you have those cost concerns, then I would either suggest that you consider litigation, or you certainly limit the amount of arbitrators on a panel to 1. And again, this all gets crafted, it all gets tightly pieced together, and it goes into a provision that when you sign off on a contract, you may not think twice about it, right? But when a dispute comes up, suddenly this is the most important provision in a contract. So this and things like indemnification, these things wind up being the most important provisions when something goes wrong. Not an issue at all. If everything's hunky-dory, you have a contract, it's 50 pages, 100 pages, 20 pages, 1 page, whatever it is, you're not thinking about this. But when you get into a situation where something does go wrong, this is the first place an attorney's going to look to see what your rights are, which jurisdiction governs, what form you need to be in, and any other considerations concerning an active litigation. Well, I hope this was valuable. I hope that people feel that they learned a lot today. If you have any questions, if there's any follow-up, if you want to know more about these topics, feel free to email us or call us at 646-386-0990 and send us a note. Let us know what it is that you'd like to hear next time for our next live, because we as business attorneys are here to provide value. We're here to hopefully give everybody a general sense of the legal process and educate everybody a little bit about what the law looks like. Once again, I'm Ross Pitcoff of the Pitcoff Law Group. I thank everybody for participating, and I will see everybody next time.